On behalf of Parentalrights.org and Parents' Rights US and a rapidly growing number of allied organizations, I want to thank Senator Jim DeMint and Congressman Pete Hoekstra for their leadership on this important issue of amending the Constitution of the United States to introduce the concept that parents' rights need to be a protected, enumerated right in the Constitution. There are two basic rights two basic reasons that you ever amend the Constitution. One is to preserve our law and traditions from potential threats and erosion of our rights. The Bill of Rights serves as the chief example of amendments that are designed to preserve the existing rights of the people. At other times, it's absolutely necessary to change the existing law. The 13th, 14th, and 15th Amendments were clearly necessary to end the evils of slavery and establish the principle of equal protection for all Americans. The Parental Rights Amendment follows a pattern of the Bill of Rights. The goal of this amendment is to preserve our existing law and traditions against judicial erosion and the ever-growing threat of international law. Sections 1 and 2 of this amendment do nothing more than restate the time-honored doctrines of the Supreme Court on parental rights. We are simply changing parental rights from an implied right based on judicial opinions to an express right based upon the actual constitutional text. Section 1 faithfully employs the words and phrasings of the Supreme Court's decision in Pierce v. Society of Sisters from 1925 to declare that the liberty of parents to direct the upbringing and education of their children is a fundamental right. Section 2 carefully follows the words of the Supreme Court in Wisconsin v. Yoder from 1972 to declare that parental rights, while very important, have limits. The government may intervene when the interest is of the highest order and not otherwise served. This section is a correct statement of current law. Today, when the government has proper evidence of child abuse or neglect, for example, it may and should prosecute a parent who's responsible for such behavior. Section 2 ensures that this principle remains intact. Parental rights are fundamental, but they're not absolute. Section 3 preserves the current principle that only American laws govern the relationship between parents and children in this country. The use of international law is a rapidly growing trend in our judicial system. One federal district judge in New York has on 2 separate occasions ruled that the UN Convention on the Rights of the Child already binds the United States under the doctrine of customary international law. An Ohio court ruled on an obviously flawed premise that the Senate had already ratified this treaty, which of course it hasn't, and therefore, based on that ratification, ordered parents in the case before them to stop smoking in the presence of their children because it harmed the health of the children. Section 3 of this proposed constitutional amendment makes it clear that the only law that can be used in American courts regarding American families is the law made in America by our own legislatures or by the people themselves. The use of international law for domestic purposes is utterly contrary to the idea that this nation is a self-governing republic. This section is necessary, especially in the context of international law. Under the Vienna Convention on the Law of Treaties, international legal obligations are of superior rank to all forms of national law, even our Constitution. However, there's an exception. Under Article 46 of the Vienna Convention on the Law of Treaties, a national constitution that deals with the capacity to make treaties is an exception to this primacy of international law, even in international tribunals. Thus, Section 3 makes it clear for domestic law purposes and international law purposes that it is illegal to use a treaty to overturn parental rights in this nation. This should be a bipartisan issue. President Obama recently declared, in the end, there is no program or policy that can substitute for a mother or father. Every member of Congress who agrees with the President on this principle should be in favor of this amendment. Every member of Congress who believes that Pierce v. Society of Sisters was correctly decided should be in favor of this amendment. Every member of Congress who believes that Wisconsin v. Yoder was correctly decided should be in favor of this amendment. And every member of Congress that believes that American legislators only should decide our public policy on this subject should be in favor of this amendment. On this last point, a post-election Zogby poll sponsored by WorldNet Daily makes it clear that virtually every sector of the American people agrees with this last proposition. When asked if they wanted American judges to use only American law or American law mixed with international law in our courts, the public was overwhelmingly against the idea of using international law for this purpose. The majority of Republican voters reject international law. So do the majority of Democrats. Those who voted for McCain, those who voted for Obama. The majority of union members reject international law. NRA members reject international law. Every region of this nation rejects it, every age group, every racial group. This is a bipartisan issue among American voters, and I truly hope and believe that it will become a bipartisan issue on the Hill as well. The gap between the values of the Hill and the values of the American people has grown too large on too many issues. The very best place to start to show the American public that we can work together for shared values is here to protect the American family.